You can already feel the courtroom rhythm, half banter, half business. Judges sometimes lighten the tone early, but don't be fooled. The stakes here are heavy. This isn't just another traffic ticket hearing.
If anything.
Maybe push him.
Yeah.
May I?
Why
He's
not?
present.
Who's to say otherwise?
You can, Judge. You certainly
Oh,
can.
I can?
You certainly may.
Last time I checked the rule book,
I don't have that option at home.
that's the difference. That's why we find you here so much, Your Honor.
Armando, what is this? Yeah.
Brian's going to stand in for me.
Stand back.
Stand back.
You're just throwing in the towel?
I'll tell you, not at all. Tell you what the weather forecast is this week.
Not at all.
What we have here on 8/27 was a probation order that my son, that is before the court. Okay. All right, so he's on probation.
Correct.
Where is he?
In your third row.
Come on up.
You'll recall, Judge, that this was a
What are we here for?
defendant pled guilty, jury found him guilty. And,
Yes, how can I forget?
But
That long ago.
well, it's not one of our ordinary process, but that's why I wanted to remind you.
when we left court, whatever day that was, a couple weeks ago, court asked us to come back today, September 11th. When I checked dockets, I suppose either Monday or Tuesday, I don't recall, I realized we weren't on a docket, and also learned that there had already been an order sent to the jail for Armando to start his weekend time that the court ordered this coming Friday.
Okay.
And I think some of this was just ships passing, because I thought we'd at least have an opportunity to come to the court. As the court gave us the opportunity to say, how are you going to do this and when are you going to do it? I think I have at minimum an obligation to ask the court to reconsider the jail time. I know that that probably isn't going to happen, but I'd like to say it on the record, just in light of Sir,
You can always ask.
will the court reconsider its position on the upfront?
I considered it. I've considered it fully from the out.
Classic defense move, asking the judge to reconsider. And here's the truth. Judges rarely change their minds once they've ruled, but filing the request still matters. It preserves the record for appeal and shows the lawyer fought every angle.
And the statute is, I think I had made some comment about it. The statute that was enacted in what is one of the most humanitarian statutes the legislature has ever done. Generally, they don't write statutes where people who are involved in an accident but had nothing to do with the cause of the accident have an obligation to help just because you're involved in it and you have an affirmative duty. And here, of all things, we've got it wasn't like somebody got a little bump on it, they sprained an ankle. It's death. And the statute, the spirit of the statute would be meaningless if there wasn't some appreciation to the responsibilities that are necessary behind the enactment of that and why people are supposed to help others. And it's a shame that has to be legislated, that when you're involved in an accident, that that you're ordered and you could be indicted for not following the orders of.
This is a big one. The judge is breaking down the duty to render aid law. Translation: if you're in an accident, even if you didn't cause it, you can't just bail. You've got a legal obligation to help or call for help. And ignoring that, felony territory.
Staying at the scene, trying to help, and if you can't help, get help. None of that was done. He fled. Others had to take care of the mess. And plus he was intoxicated. He was operating a motor vehicle, on the roadway there, which, I mean, there were multiple things that are bad. And yeah, the sanctity of life and the value of life cannot be appreciated if the statute is, it's not appreciated if the statute isn't followed and people are held accountable when by the facts they're shown to be culpable and you were convicted. The jury, even though they didn't order you to go to prison, you were convicted of this crime, which is serious second-degree felony. And the sanctity of life would seem to be lessened if this court didn't assess punitive measures. And certainly nobody wants to go to jail, but he was looking at what the legislature enacted as possibly 20 years in prison. And so it's serious, and if it would have been maybe a lesser set of injuries, it might be different. But no, the value of life, you can't put a price on it. So it leans toward the high end of what I am allowed to do on probation terms, and that is assessed 180 days in the county jail. That is going to continue to be assessed. Now, the court may curtail it because I've got it under probation. I might end it sooner than its natural length, but this court is, by its orders, not only bases it on the circumstances in this case, but it sends a message as well, like all assessments of resolvements of cases, for the public to see what can happen, what's important, what has serious consequences to it. And truly in this one, these were serious. Shouldn't have ever been in. Shouldn't have been intoxicated 3 times. Should be behind a 4,000-pound missile. But nonetheless, you're involved in an accident and you have a duty to help. Stand by and stand vigilant. I think that you said them shouldn't flee, and people have to go find you. And those are all negative circumstances for something like this. So the court assessed 180 days, which is the most I would say as a condition of probation. And at this time, I'm not changing. I know. We'll see how things work out, but
Notice the balance here. The judge isn't maxing him out with prison time, but 180 days in county jail sends a strong message. It's a mix of punishment and probation. Think of it as rehab with consequences. Fair justice, or too soft given the death involved?
The second request,
Yes.
Judge, if I may, is to Mondo to begin the time next weekend. He is, if I'm stating this correctly, completing a job that involves flooding about 150 acres related to crawfish farming. It's a big job. I think the court would appreciate that if he can have the time to finish that instead of starting tomorrow.
State have anything to say?
I don't have any objections, Judge, as long as he does the
The
job.
court. The court will grant the request. Do you have anything to say?
No, sir.
Well, I'll say it. I'm granting your request, but I'll bet you the lady who died wished she had another week of life. She didn't get an option. Hopefully.
Oof, that line lands hard. The The judge allows him to finish his farm job before jail, but reminds him, the victim never got an extra week of life. That's courtroom poetry, and a brutal reminder of what's really at stake.
You don't drink irresponsibly. Hopefully, this made a lesson. Hopefully, you don't drive irresponsibly, intoxicated. And hopefully, if you're involved in an accident, you stop and do the decent thing, and that's stop and try to render aid, try to get help, medical help, which are all mandates of the statute. This court has a lot of power and authority, but I can't bring a life back. But we can take measures that send a message and an example, and also try to serve the ends of justice under the circumstances of a case like this. And again, nothing's more precious than human life. And we're all in this together, and it's up to each of us to be responsible with the way we take care of others. What's the great saying? I am third. Who's the great, wonderful
Gail Sanders.
Yeah, Gail Sanders.
Yeah, Sanders. Yeah.
Supreme being is first, others are second, we come in third. That's a wonderful saying. Here's in the Brian Piccolo movie. Right. So hopefully important lessons are learned, and others will see how serious this can be, and it is treated seriously, and maybe that will help people make decisions more responsibly than they would have without being aware or knowing of these circumstances. Hopefully it sends a message. But so he'll be reporting before 6:00 p.m. next Friday, week after this. Yes. Okay. To begin. And then you want to come back and talk to me about how things are going and what he is doing on probation and how the probation office responds.
I checked with him, Judge. He hasn't reported yet, but that's just he's done his intake. She just has not met with him yet.
Okay. Well, are you meeting with her right now?
No, that's nothing to foul, Judge. It's just the scheduled date has not occurred yet. We're here too quickly.
He reported after the case ended. He has not had his first meeting at the probation.
Well,
intake, but not probation.
I think it's important that gets done before a mistake is made. Inadvertent.
What date did you say?
The 18th.
18th. So she'll actually meet with him before he goes in.
Okay.
Week from today. Yes, sir.
Okay. All right. Okay. Good luck to us all.
Thank you.
Thank you. Daniel Lee Harvey Jr., please.
He's in custody, Judge.
I was looking out in the audience. Okay. Two cases are called 24 CR 1041. And this is obstruction of retaliation. And it was an indictment handed up on May 8th of last year. And in summary, it states that on or about March 30th, 2024 in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation by committing assault in retaliation for or on account of the service of the victim acting as a public servant, namely a Beaumont police officer. And then 24 CR 1818 is an indictment that was indicted, looks like about over 3 months later on August of last year.
Yeah, rise up here. Same
And it
circumstance.
also alleges on or about March 30th, 2024, you illegally possessed hydrocodone, and it's a state jail felony. It's also alleges that this was in 1,000 feet of a playground, namely Texas State Fair, located at Ford Park, 5115 IH-10 South, Beaumont, Texas. And the third degree felony in obstruction or retaliation carries with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. And a state jail felony with illegal possession of controlled substance carries with it no less than 180 days up to 2 years in the state jail and a fine up to $10,000 can also be assessed. What's his bond code?
Judge, you said it at no bond at his last appearance, that's positive. And the court does not recall Mr. Harvey was quite disruptive in the court. And it took quite some time before we could get his result. And I believe, and I'm stating all that to remind Your Honor, because I believe that was one of the reasons.
I don't have a
why you
report
said
in the
that
file.
He might be waiting to be scanned, Judge.
What was the result?
I'm
He
looking
was
at that.
positive for THC, Judge, is my recollection. I was in trial in Orange County.
Hold on. I got it.
Oh, you got it?
Nice work coming to court. Investigated. That's good.
It's well in my office. Had a stern discussion with him in the wake of this, outlining terms and conditions, making sure that he's a copy of the court's current terms and conditions, which detail and specify some THC related products that he signs. So I believe those were that those bond conditions were put in place in I think October of last year, if my recollection is right, but that are much more specific than they used to be. But nonetheless, we're asking the court to set some bond amount, and again, whether it's compliance with a drug patch or some other terms and conditions that will ensure his compliance. I think Mr. Harvey's assured me that he will follow the terms and conditions going forward.
Judge, I've tendered you a copy of the motion to revoke probation that's pending in his misdemeanor court. And the reason why I did that is because he was on probation at the time in which these offenses were alleged. And to me, it shows not only a pattern of not following rules, but definitely goes back to, unfortunately, Mr. Gertz wasn't here to see how his client acted today. He's representing, Mr. Gertz represents him on this.
Well,
So the state stands by the court's ruling and believes that a no bond is what's appropriate in this matter.
anything else?
No, Judge, I said that motion to revoke his probation is still pending. And the outcome of this case is going to dictate what happens with that motion. So, but again, we're asking for to set I believe his previous bond was $10,000 in these cases, if I'm not mistaken. We're asking the court to set a bond and bond conditions that are appropriate and that he can comply with it. And I hate to be, say this, and I'm sure there's an answer that I just don't know the answer to, but I know there are, in Chapter 17, there are specific offenses for which the court can set no bond for violations of protective orders and bond conditions. I'm not under the impression, or at least I can't find a section that says the court can set no bond for a regular offense that's not delineated by the code. But I may be completely wrong about that. And if I am wrong about it, I'd love to know where that is. So I think
he's entitled to a bond under these circumstances, but it's not going to be an easy one. I would think. You've got the on probation for about 6 months. And he's out for, by the way, unlawfully carrying a weapon. And so he's charged with two serious offenses of assaulting a public servant. Yeah. Oh, thank you very much. And it is a possession of they have any particular amount?
The whole reason why I provided the motion to revoke probation deal is so that the court was aware that this man's already been given several opportunities to follow sets of rules. I don't know that there is a set of rules that we can give him to ensure that he's not going to either A, break the law or consume drugs of some kind. I mean, I see a pattern and I'm concerned. So I always will respect whatever the court decides.
All right. Anything else?
No, Judge.
Okay. Here's what we're going to do. In third degree felony, I'm going to set a bond of $50,000. Plus the condition of that's what I'm going to set in that one. We're going to have conditions on each of these bonds. $25,000 on the second bond, the second case, state jail felonies. And number one, you're going to have a drug patch at all times as a condition of bond. It will test you, and you fail that test and you're going to run out of bond opportunities. And also on this one, the obstruction or retaliation of where you are all the time.
This is high-tech accountability, GPS tracking plus a drug patch. It's like the digital leash of modern justice. Question for you, does technology make these punishments smarter or just more invasive?
So you're going to have a GPS device on you, so I know where you are. You're going to have terms and conditions of probation, which
You mean bond, Judge?
bond, because they're going to be similar to terms. I was thinking about terms of probation. You're not going to just be able to amble about town. I want you at home, except work. You're working somewhere.
Yes, sir.
Except work or school. Are you going to school somewhere?
No, sir.
Or medical needs.
In my office too, please, Judge.
And to and from the lawyer's office. And if you have to leave the house to go to and from the lawyer, it's the most direct route possible. And the GPS will show it, and we'll keep an eye on it. You have to know the most direct route and use it. And if it's medical, same way, to and from the most direct route. And work, same way, to and from.
Yes.
You've lost a lot of privileges because of the circumstances of these two offenses, plus you commit a crime while you're on probation for another offense. And that kind of you've punished yourself. Yeah, I'm certain that the misdemeanor people are going to wait on what happens here.
Yes, sir.
Did you need this back?
No, sir. I like the court being informed.
Right. Did we miss an I dotted or a T crossed?
Not in my opinion, Judge. Trial date shows to be December 8th at this stage, Jeff.
Where do you work, sir?
I work in Wayne Merida, job insurance.
And how much do you make an hour?
22.
Okay. Well, that's almost $50,000. How long have you been working there?
Well, yeah.
Okay. Well, so you were working there when this happened? Maybe not.
No, Judge.
Was this before?
This
Did you get a job after all of this?
This is
Yes.
Well, that's a lot of money that you'd lose if you go to prison, probably. And you got a lot to lose by committing crimes. It has consequences. Some consequences are forever. You carry that around forever. A conviction, felony conviction, you'll carry it around like carrying around a body. It's just wears you down. You lose opportunities and rights and privileges.
That's why.
And I don't understand. You don't think, of course, I'm sensitive about presumption of innocence. I'm intimately familiar with that, and I believe that. But why would anybody, it's a rhetorical question, why would anybody think assaulting an officer or a police officer would be a benefit in any way to you? And while you're, and then the drug thing, and then you're carrying around drugs, and that's foolish.
I understand that. Thank you.
Where'd you get your drugs from? It's rhetorical. See, he says don't answer. Why do you think he said that? Because he knows it's wrong too. We all know it's wrong. But you know it's wrong. Illegal drugs are wrong. We just put some lady in jail this morning for testing positive for drugs. But mistakes have consequences. Yeah, parents, right?
Yes.
Were they good parents?
Yes.
Did they teach you that mistakes have consequences? You pay for mistakes. You do well, you get rewarded. That's right. You do well, you get rewarded. If you make a mistake, you're going to get your hand slapped. Or your rear end's swat. Somebody's going to spank you. But why do we do that? That's because we want people to make the right choices. And those are three bad choices that they're talking about here. Okay, fix that.
Thank you, Judge.
Can you?
Yes,
Can you
sir.
fix it?
Yes, sir.
All right. Yeah, that's some people come up here and they're not capable. There's no hope. I think you know better. You do. You're able. That's what's frustrating about it. You know what the right thing is. Do it. It's so much easier for you, your family, everybody you touch in life. You want to make proud of your actions. You got to do that one step at a time, every day in the right direction. That's success. Okay.